All right, everybody, let's begin. Hi, good afternoon. I'm Pete Aldis. I'm a staff attorney at the Consumer Rights Project at Legal Aid Center of Southern Nevada.
And I am Taylor Altman. I am also a consumer rights attorney here at the Legal Aid Center. And we are going to be talking about what now with my student loans after the Supreme Court's Biden v. Nebraska ruling. Okay, we're going to go ahead and get started. Can everybody hear me okay? Okay, so today I'm just going to go over what we're going to cover. So I'm sure many of you have heard about the decision, the Supreme Court's latest decision in Biden v. Nebraska. We're going to talk about how that's changed the landscape of student loan and student loan repayment. Pete will talk about a Fresh Start program for loans that are in default. We're also going to talk about income-driven repayment, or IDR, adjustment, and a new IDR plan. That's a type of repayment plan. We're going to be going into some more detail about that. We're also going to be talking about rule changes for statutory discharge programs and interest capitalization. Some complicated topics, but we're going to give you kind of the basics about what's changing with these rules and how that might affect your student loans or the student loans of your clients. Pete will talk about the tax consequences of student loan forgiveness, as well as a new policy for discharge of student loans in bankruptcy. Because a lot of times, as you guys might have heard, discharging student loans in bankruptcy can often be challenging. So new rules should make that, should kind of expand that window, make it a little bit easier to do so through bankruptcy. And then we'll be taking questions at the end. Okay, so to talk about student loans and what happened during the pandemic. So pandemic hit on early 2020, as we all know. The federal government decided to pause student loan payments and to set interest rates at zero. Basically just kind of a one-time thing to give people a chance to catch up, and because a lot of people were out of work, businesses were closed, schools were closed, to kind of give people some breathing room during the pandemic. President Biden also proposed a big loan relief package under the HEROES Act, and HEROES is Higher Education Relief Opportunities for Students Act of 2003. And under the authority of this HEROES Act, he was going to offer borrowers who earn less than $125,000, that's a lot of borrowers, cancellation of up to $10,000 of federal student loan debt and up to $20,000 for Pell Grant recipients. So this would have been an amazing package, helping a lot of people, forgive student loans, and actually the proposal would have cut the number of student borrowers in half countrywide. So it was a wonderful proposal. However, the Supreme Court did not agree with the Biden administration and a lot of our legal aides that the HEROES Act, they said, did not give Biden the authority to implement this relief package. So unfortunately, it was struck down. And now the Biden administration says that it will pursue debt relief under alternate authority. But so far, we don't know what the details or timeline is for this. So what we recommend is going on studentaid.gov. There'll be updates, watch the news, check to see what details and timeline will be forthcoming for this new relief package. The main thing to come out of this is that student loan interest, unfortunately, is going to resume starting on September 1st, so in a little less than a month. And payments on student loans that were paused during the pandemic are going to resume starting in October of this year. So there are certain ways that you guys can prepare your clients for when the pandemic pause comes to an end. Okay, so to prepare for the end of the pause, what we recommend is that every student borrower log into their studentaid.gov account to check on who's the loan servicer. A lot of times during the pandemic, the loan servicer may have changed. Verify your contact information, especially since people have moved around during the pandemic. Check your current loan information, know what loans you have outstanding. Are you under any repayment plans? Do you have any defaulted loans? All of these things, they can possibly be corrected, but it really helps to know kind of the landscape of where you stand with your student loans. If your loans are in default, there's a new Fresh Start program to help you enter repayment in good standing that Pete's going to talk about next. Assess whether you have a right to a federal loan discharge. And there are certain reasons for discharge. For example, total or permanent disability of the borrower, if the borrower has passed away, if a school has closed or if a school has misled the student borrower. Different reasons for discharge. And what we recommend is going on studentaid.gov. It has a really extensive explanation of all of the different types of ways you can deal with your student loans. And it's, especially for clients, it's in a non-legalese way of explaining things. And so it really helped me as I was doing a deep dive into these topics. And the website does really go deep, so I recommend going on studentaid.gov. Another thing low-income borrowers should consider is income-driven repayment, or an IDR plan. This would calculate the monthly repayment amount based on income and family size. This could really be a benefit to many of our clients. If an IDR plan isn't available or payments are still unaffordable for whatever reason, the borrower may consider using a temporary deferment or forbearance to postpone payment. They can do this for a little while. Eventually, it'll kind of catch up with them, but forbearance or temporary deferment can give them a little bit of breathing room with their student loans. So just to go back to the beginning for 1 minute, there's a number of different ways to deal with student loans. So one way we talked about is repayment plans. That includes the IDR plan. Sometimes consolidation, if you have a lot of different student loans, consolidation might be a way to go, and then enter repayment. There's deferments and forbearances. There's also loan forgiveness programs like the Public Service Loan Forgiveness Program that we all have the benefit of here at Legal Aid. Discharge, as I mentioned, closed school, death of borrower, bankruptcy, total permanent disability, and also there's a borrower defense loan discharge, which applies to certain loans. So that's kind of the landscape of how to deal with one's student loans and some of the changes that are going to take effect after the end of the pandemic pause. Oops. Okay, now Pete's going to talk about Fresh Start.
Thanks, Taylor. So the Fresh Start program is a program for borrowers who are in default on their federal student loans at any point up to and including this pandemic payment pause. So in default means you had not made payments on time, and there are a lot of negative consequences that come from being in default on your federal student loans. If I were to rank the number or the different people or organizations that you could owe money to and what would be the worst, the federal government is probably the worst organization to owe money to, because they can do things like take your tax refund, take your wages. They don't have to sue you. They don't have to get a judgment. And then there are a lot of other consequences related to student loans specifically that kick in when you are in default on student loans. And this Fresh Start program is designed to get as many borrowers as possible out of default and back into repayment, and to suspend all of those negative consequences as we come out of the pandemic pause and into repayment. The most important thing to bear in mind with the Fresh Start program is that it is a borrower, an opt-in program. You have to say, I would like the benefit of this Fresh Start program. They are not going to automatically put you into it. Now, hopefully servicers are going to reach out and tell everyone in default, you should sign up for this. Would you like to sign up for it? But they are not going to automatically put you in. So you must opt into the Fresh Start program. You should also, in most cases, transition into an income-driven repayment program to avoid future default. And there's a couple of ways specifically in the Fresh Start program to do that. I know that Taylor had said earlier that income-driven repayment is great for low-income borrowers. It's actually good for almost every borrower. Even relatively high earners can benefit from an income-driven repayment plan, because the idea is that your payment is based on your income and your household size. And so for people with large payments, even if they have a larger income, they can still see a reduction in that monthly payment. So again, the basic idea is that getting out of all the benefit you do, sorry, I'm losing it. You do, sorry, I'm losing it. All of the negative consequences of being in default go away when you opt into this program. So that, just to clarify, you can get your tax refund. You can apply for a Fresh Start. Just some general rules on how you get out of default. You can either consolidate, which is to take all of your loans and get a new loan. And that pays off the loans. And when you consolidate, you get a you are now current on your new loan. In general, you get the right to consolidate one time with your federal student loans, but with the Fresh Start program, you get another chance to consolidate. So if you've already consolidated, you can do it again. If you consolidate as part of this program and you get in default later, you haven't lost your opportunity to consolidate. The other good way to get out of default is rehabilitation, and that is making a series of payments on time based on your income. And once you make those payments, 11 payments on time, you are now considered rehabilitated and you are back on track. So you have the right to do that, even if you've done it before. And again, that's usually a one-time option. You have one chance to rehabilitate your student loans, but you now get another chance with the Fresh Start program. You have the ability to get new student loans. Usually when you're in default on student loans, they will not let you get new loans. So if you go to school, you drop out because you didn't get that degree, you're not able to make your payments and you go into default. And now you can't go back to school to finish your degree because you are not eligible for federal student loans. With the Fresh Start program, you will be again able to take out those loans, return to school, get your degree, make some money. So there's a lot of benefits to Fresh Start, but the biggest one is you need to, the biggest thing to bear in mind is you need to reach out to your servicer and get into the Fresh Start program. All right, the next topic we're going to talk about is the income-driven repayment adjustment. So they announced this about 2 weeks ago, and the idea is that the income-driven repayment program, which again is a wonderful program that gives you affordable payments, and very importantly, after 20 or 25 years of those affordable payments, forgives the remaining balance, has not been working as well as people would like. A lot of borrowers were steered away from income-driven repayment programs and into deferment and forbearance by some unscrupulous loan servicers. A lot of lawsuits came out of that. A lot of people were not in the right program. They didn't have the right type of loans for income-driven repayment, or they just weren't told about income-driven repayment. And so in response to this problem, the Department of Education has made a one-time adjustment to all borrowers that gives them credit for payments that they should have been able to get credit for under this income-driven repayment forgiveness program. So the ways that let me start by just going over the different types of income-driven repayment plans. There is the revised pay-as-you-earn repayment plan. That's the one that offers a 20-year forgiveness. The original pay-as-you-earn repayment plan, both of those are for undergraduate borrowers. There is the income-based repayment plan, which is the most common. Again, it's a 20 or 25-year repayment program. And then an income contingent repayment plan. It's a little bit older. It doesn't have all the benefits. So by and large, people are either going to be into the revised pay-as-you-earn repayment plan or the income-based repayment plan, or the new plan that we'll talk about a little bit later. Great thing about all of these income-based repayment plans is you can go on studentaid.gov, you can enter your information, and they will tell you which is the best plan to get on. So you don't have to do all the hard work yourself. So credit under this one-time adjustment is given for any payment made while you're in any other repayment program. So if you were just on your regular scheduled program, pay it off in 10 years is the typical rule. You were on any of those programs I talked about. You were also in periods of forbearance or deferment. And there are some limits on the forbearance and deferment. Like you usually have to be in 12 months of forbearance. But also, if you had made payments prior to consolidation, they used to not count those. And in general, they won't count them in the future. They say that it has to be loans under the direct program, and it had to be payments made prior to, after consolidation. But under this adjustment, all payments made under any program before consolidation, after consolidation, are all credited towards your 20 or 25 years of forgiveness. And for a certain number of borrowers, considering that these programs have been in place in one form or another since 1994, they have now seen their loans forgiven because they actually had 25 years of payments, but they had not been able to get credit until this income-driven repayment adjustment kicked in. Taylor will tell you about the new income-driven repayment program.
Okay, so post Biden v. Nebraska, there is now a new IDR plan. The current repay plan, as Pete was just talking about, is now called Saving on a Valuable Education Plan, or SAVE. I think the government comes up with the acronym and then fills in the words. But it's good because it's memorable. Repay, save. This plan, the new SAVE plan, is going to be fully implemented July 1st of next year, with some aspects effective just a few days ago before repayment starts again in October. So there's an automatic enrollment in SAVE, bless you, for enrollees in repay. So someone already in this IDR plan is going to be automatically enrolled in SAVE. Certain borrowers might have to consolidate before they become eligible for SAVE. So I believe it's FFEL borrowers, Parent Plus borrowers, and some other types of borrowers might have to consolidate loans first before going into SAVE. The benefit of SAVE is that it increases the amount of income that's exempted from calculating monthly payments, meaning that the monthly payments are going to be reduced. Until July 1st of next year, the monthly payments are only going to be 10% of that portion of the borrower's income above 225% of the federal poverty line. That seems very abstract, but there's actually a loan calculator, a loan simulator on studentaid.gov that we recommend that you guys take a look at, which should be able to perform at least some of these calculations. If for whatever reason it doesn't really meet your needs, Pete and I can probably look into a better loan calculator for you. We found other consumer type law calculators through NCLC, which is the National Consumer Law Center. They also offer a really great student loan guide. If anyone needs the login for that, you can feel free to see us after. So some other details about SAVE after July 1st of 2024, 5% of a borrower's income above 225% of the federal poverty line. Only that portion will be counted if a person has undergraduate loans, 10% if they only have graduate loans, and if they have both undergraduate and graduate loans, there's going to be a weighted average of between 5 and 10%. So a lot of this is going to be very specific to people's income, how far above the poverty line are they, where do they fall, and that would hopefully be calculated on the studentaid.gov payment calculator. Okay, lots of details about this new IDR plan. So after the payment pause ends in October, Department of Ed is going to stop charging SAVE, or formerly repay borrowers, any monthly interest that's not covered by their monthly payment. So the monthly payment amount is going to go down because it's not going to include any additional interest. Married borrowers who are filing their taxes separately are no longer going to be required to include their spouse's income as part of their own income when calculating the monthly repayment amount, meaning the payment amount goes down because you're no longer calculating spouse's income. The repayment period before forgiveness is changed for some borrowers. There are some finer points about that if you're curious, we can talk about after. There are also new options for borrowers in default. So they're going to be eligible for an IBR, that's the income-based repayment plan. And I'm sorry, a lot of this is going to sound like alphabet soup. There's IBR, ICR, IDR, but you can think of these as all different flavors of repayment plans. The Department of Ed will automatically enroll borrowers in an IDR with the lowest payment if the borrower has met certain guidelines. And there's also a new pathway out of default. So if a borrower can provide information to the Department of Ed showing that they would have been eligible for a $0 payment under an IDR plan at the point of default, they're no longer considered to be in default. So it's really kind of helping borrowers who ordinarily would be considered in default have a new pathway out. Okay, so some other changes that are happening post Biden v. Nebraska. New rules and regulations have gone into effect on July 1st. More borrowers are now going to be eligible for discharge. So at the beginning of the presentation, we talked a little bit about reasons for discharge. Bankruptcy, the borrower passes away, total and permanent disability, and school misconduct or school closure. There are other reasons for discharge, but those are the main ones. It'll be easier for many borrowers to obtain relief under these new rules, and I'm going to talk about 6 big changes that are coming soon. So previously to this, the loan balance in a student borrower's account might kind of go up or balloon over time due to the addition of capitalized interest. And this is taking any unpaid interest and adding it to the outstanding principal balance, making it look like the loan is a lot more. But the new rules provide that the interest is not going to be capitalized in this way in the following instances. So if a borrower first enters repayment, there's not going to be that, balloon amount capitalized interest. After a forbearance, when the borrower enters default, when switching out of one of these different repayment plans, or during periods of negative amortization in an ICR or alternative repayment plan. So basically what that means is that every month you're paying more in interest than the principal amount. Negative, it kind of flips, negative amortization. So they're not going to penalize borrowers by adding on this capitalized interest. Okay, so some other changes. The new rules are going to make it easier to discharge student loans based on total and permanent disability. So this kind of expands the categories for people receiving SSA benefits, people under SSI, SSDI, other forms of Social Security. New groups of these individuals will be eligible for a discharge of their student loans. The new rules are also going to make it easier for borrowers to obtain the borrower defense relief that I mentioned. It's an application to say that they have some defense against repaying these loans. It also increases access to relief for those harmed by deceptive and abusive school recruiting and enrollment, because as we probably heard in the news in recent years, there have been a lot of fraud with for-profit schools, kind of taking people's money, not giving them the degree that they want, or giving them completely useless degrees that they can't use in the job market. So there's more relief for those types of borrowers who attended those schools. As I said, closed school discharges apply to more students, and there's also an easier path to false certification discharge, including group discharges. There's a number of different ways why there might be a false certification. This has to do with school fraud and things like that. There's also improvements to the Public Service Loan Forgiveness, or PSLF program, which we're eligible for as legal aid employees. So PSLF is available to borrowers who work full-time in public service jobs like we do, while they make 120 qualifying monthly payments on their federal loans. So after 10 years of qualifying time, the Department of Education will cancel the remaining balance, which is a great benefit to all of us. The new rules are going to reduce some of the barriers that have historically prevented borrowers from benefiting from PSLF. Basically, what this means is that more types of payment count towards forgiveness, including late payments, installment payments, any payments made in a lump sum. So things that ordinarily wouldn't have counted towards the forgiveness time period will now count. And also the new rules are going to count more types of deferment toward forgiveness. So for example, if a borrower has undergone cancer treatment, military service, there are a number of different ways to that certain deferments for, I think, nursing programs and other things like that will give the borrower, will count more credit time towards the ultimate forgiveness of the loans. Okay, now Pete's going to talk about tax consequences.
All right. So one of the biggest surprises people find out when they learn about forgiveness after these income-based repayment programs is that in general, forgiveness of student loans is taxable by the IRS. Anytime you have a debt and then you don't have to pay it, the IRS considers that income for you and they want to tax you on that income, even though you didn't receive an actual, you didn't receive money. And there is an exception for forgiveness under these income-based and income contingent repayment programs, but only through December 31st of 2025. As part of the American Recovery Plan Act, the American Rescue Plan, the tax consequences of forgiveness have been waived, but only through December 31st of 2025, which means that if you hit your 20 or 25 years of repayment after that time period, you are likely going to get a tax bill from the IRS. Now, there may be ways around that tax bill if you can show you're insolvent, that your debts before the forgiveness exceeded your assets. But in general, that may be a really unpleasant consequence of this otherwise wonderful thing of having your student loans forgiven. We will see after December 31st of 2025 what Congress wants to do about this potential tax consequence. If, especially as more and more borrowers qualify, if people have to start paying those tax bills, there may be kind of an uproar and Congress may decide to extend that exception or just get rid of it entirely. But If they don't make any changes, then any forgiveness will be taxable, with the exception of public service loan forgiveness. So again, public service loan forgiveness is for people working in public service, nonprofit jobs, government jobs. Anybody who works those 10 years, makes those 10 years of payments, does not have a tax consequence. Also, it isn't forgiveness, but if you qualify for one of the other discharges, a student loan discharge, a total or permanent disability discharge, the borrower defense to repayment discharge, none of those result in taxable income. So a little bit of good news. And then we'll get into a much more complicated topic, which is discharge of student loans in bankruptcy. The simple answer is it's really, really, really hard to discharge student loans in bankruptcy. The law just says that student loans are not dischargeable in bankruptcy unless the borrower can show that they pose an undue hardship. But what the law does not do is explain what undue hardship is. So that was left to courts. And a long time ago, courts decided that the appropriate way to determine undue hardship for student loans was a test called the Brunner test, and it has 3 parts. The borrower has to show that due to a hardship, that borrower cannot maintain a basic standard of living while repaying their student loans. So not just that they can't live a normal life, they can't even maintain their basic standard of living. Not only that, but that hardship has to continue for the majority of the repayment period. It can't just be that you can't afford to maintain your standard of living while you're in your first few years of employment, or while you're dealing with, for instance, illness of a loved one who then recovers. You have to show that this is going to be some very long-term hardship. And then finally, there is a good faith requirement. You have to have made a good faith effort to repay your loans and still not been able to pay them. So under this test, it is very, very rare for borrowers to successfully discharge their student loans in bankruptcy. There is a new policy that is going to try to help that. The general kind of overview of how this works when it works right now is that after filing bankruptcy, it is up to that debtor, the person who files the bankruptcy, to file a separate lawsuit in their bankruptcy case saying, I want these student loans to go away. And just like any other lawsuit, there will be a discovery phase, there may be medical experts involved, and then ultimately there will be a trial, and the bankruptcy judge will take evidence and will make a determination, has this borrower met this standard to demonstrate that they are totally unable to make these payments for an extended period of time. And that has been very, very difficult recently because borrowers can qualify for those income-driven or income-based repayment plans. And for many borrowers, that means that their payments are either zero or something relatively affordable for them. And that means that because your payment is affordable, you are not able to meet that undue hardship test and get rid of your loans in bankruptcy. The new guidelines implemented by the Department of Justice and the Department of Education are trying to streamline the procedures to cut out a lot of that lawsuit, to say, let's start at the beginning. Let's figure out, what is this person's income? What are their assets? What are their expenses? What is their hardship? Is this something that's likely to last a long time? And if so, can we skip all the rest of this part and get right to, maybe we can settle this case? And historically, the Department of Justice has never settled student loan discharge cases in bankruptcy. They've been very, very aggressive in fighting them. I think the theory is, if we show any weakness, if we make you think that you can get rid of your student loans in bankruptcy, everybody is going to be filing bankruptcy and claiming they have a hardship and getting rid of it. So historically, the policy has been very, very aggressive defense. Not anymore, or so they say. There is an attestation form that borrowers fill out early in the case before any of that discovery happens. And they set forth all of the facts, all of their loans, how much the payments are, all of their income, all of their expenses, all the details of their hardship, how long it's going to last. And the U.S. attorney can look at that, work with the Department of Education, and hopefully agree this person is not going to be able to get rid of their student loans. We're going to agree to discharge them as part of a settlement. By the same token, if it's pretty obvious early in the case that this person has the ability to repay their student loans, especially after the bankruptcy without other debt, they can move quickly to dismiss the case on that basis. Beyond just providing this streamlined procedure, the Department of Justice also has new guidelines that they've worked together with the Department of Education to implement that are standardizing the procedures. Because with all the different courts and the different U.S. attorneys' offices around the country, people wouldn't get the same results. Some U.S. attorneys were a little more lenient, some were more strict. Now there's standards, and there are also presumptions that are designed to increase the number of people who will qualify, who will meet this standard. So, for example, instead of just arguing, we believe this person could afford to repay their loans because we think they can afford to eat ramen their entire lives, there are IRS guidelines that say this is the amount that a family of this size is supposed to spend on food. This is the amount they're supposed to spend on housing. And using those guidelines, it's more obvious to everyone whether you in fact have a hardship that means you cannot meet those basic standards. Also, in terms of, is this something that's going to continue for the remainder of the repayment period? There's a new presumption that if you're over the age of 65, your situation's probably not going to change. You're probably not going to go get some higher paying job that's going to make you better able to pay your loans. So for borrowers that are now, and unfortunately, it's an increasing number of borrowers over the age of 65, either with their own student loans or with Parent Plus loans for their kids, they're now able to establish early on that this is a situation, whatever it is, that's going to continue. So the hope on the part of the Biden administration and the Department of Education is that with these new procedures, many more borrowers are going to succeed, and also that many more borrowers are going to take the risk. Because as somebody who has counseled people in private practice on discharging student loans in bankruptcy, it's really hard to tell them, give me $5,000 or $10,000 or whatever this is going to cost you to fight this battle with the US government, and maybe you'll win and maybe you won't. Because basically the kind of people that can afford to pay for a lawyer to fight this fight aren't the people that need the help. But now that the procedures are standardized, that the hopefully this attestation form results in a lot more settlements, it hopefully is easier for student loan borrowers and bankruptcy attorneys to agree to take this chance, to go through this process, and to get rid of these debts for people who really will never be able to afford them. And with that, we are now happy to answer some questions. We had gotten some questions in advance, and so we'll go through those, and then we'll answer questions for those of you here in the classroom. Come on up, Taylor. We'll go through these.
Thank you, Pete. So some of the questions that we got, just to summarize, a couple of them have to do with loans that have changed character. So loans that were once federal government loans that have now become characterized as commercial or characterized as private. Generally, when Pete and I were talking, that it doesn't really happen that way, that they just suddenly change character like that. That's something that the borrower would need to approve. But if there's some confusion that you guys have as to why is my loan now private, private loans are not going to qualify for anything that we really talked about, like the repayment plans, the IDRs, IBRs, and so forth. If there's a particular situation that you guys have that you want to discuss with us about the loans, they're now private, or you don't really understand what happened with the servicer, you can to us. So I'm going to skip to the first question was regarding loans that became commercial, somehow or recharacterized as commercial. The second question is, how do I know if I qualify for the pardon? And we think by pardon, maybe this person meant the pause. The eligible loans, if you had eligible federal student loans, they were automatically paused during the pandemic. We would just recommend check with your servicer and log on to studentaid.gov to see what loans you have out and where they are in the repayment process. If you want to talk about loan forgiveness or public service loan forgiveness, we can discuss the various requirements for those different programs. And one other thing, when I call, they say the loan was bought by a private company. Does that now mean I'm out of luck? Unfortunately, private student loans were ineligible for the pause. Again, nothing that what we talked about today really can probably help borrowers, unfortunately, with the private loans, but there may be some other options, and we can help you brainstorm if that's your situation. And the final question, why was I not notified that the loan was purchased and when it was purchased? If loans are being bought and sold, the servicer is required to notify you of the change. The fact that someone else, another company, another lender purchased the loan doesn't change the terms of the original loan. And also just something to note, ownership of student loans, with the exception of federal direct student loans, can be transferred independently of servicer changes. So ownership and servicer, kind of different things. Again, if you're confused about who now owns your loans or services your loans, you can feel free to come talk to us.
Yeah, and just to kind of clarify, even in cases where the federal government is your lender, what we call the direct loans, you will have a student loan servicer. That's the company that you send payments to and that sends you a bill and that handles all of the communication aspects. A lot of those are nonprofits, sometimes state-sponsored nonprofits. Just a little trivia about that Biden case. The reason why these states, including Nebraska, but also including Missouri, were able to have standing, that they had a reason to be in court in the first place, is because Mohela, which is part of the state of Missouri, was affected by the forgiveness of the student loans. I guess they made a lot of money servicing loans because the federal government, like any lender, has to pay these companies to service loans. When loans are forgiven, no more servicing fees. That was their way into court. There's a lot of dispute, including amongst the justices, about whether that was appropriate, but it's the decision now. And just in general, when you're dealing with loans like this, the entity that you're dealing with is the servicer. That servicer can change. They'll tell you. For instance, if you apply for public service loan forgiveness, you send in your certification form, they're going to route you to the servicer that's currently handling public service loans, because there's only one of them. And that can change too. And in fact, that did change a couple of years ago. It can change again. So don't get too confused, because you have studentaid.gov that will give you all the information about your student loans. All right. So those are the questions that we got in advance. Does anyone here have questions, either themselves or for clients or just curiosity? Jenny in the back. Absolutely. So public, and luckily Taylor had prepared a slide on this. Yes. So we do. And that, yeah. So what are, oh, this is it. What are the requirements for public service loan forgiveness? You have to work full time, more than 30 hours a week, in a public service job. So that can be working for a state, local, federal, municipal government. It can be working for a 501c3 nonprofit like Legal Aid Center. You can be an AmeriCorps. There are certain private companies like private fire and nursing companies that qualify. But generally, you're working in public service jobs, and you have to make 120 qualifying monthly payments. And so it's not that you have to have 10 years of continuous work for one of these or many of these employers. You have to be working at this employer in a given month. You have to have made a payment, and it doesn't have to be the full amount of the payment. It can be an income-based repayment. It can even be a $0 repayment. It can be any time during the pandemic pause where everybody that was working at an employer got credit. But you have to have 120 qualifying monthly payments. It also has to be a federal loan. Like all the programs we've talked about today, they only apply to federal loans. So if you make 120 of these payments, you can then apply. And there was an exception to this for a little while, and there probably will be a few more. But in general, you also have to be working at the public service job when you apply for forgiveness. If you meet all of those requirements, your loans will be forgiven. And again, good news, no tax consequences for public service loan forgiveness. That is a good question. Do you have to be working on the day it is forgiven? And to be honest, I don't remember. I'm sure we can look that up, and I'll get back to you with the answer. Practical note: just don't quit your public service loan until it gets approved. That way you don't have to worry about it. Actually, yeah, I don't know. It does not have to be consecutive work. again, you eventually, if you're in an income-based repayment program, you're going to qualify for the other kind of forgiveness. But yeah, you can move back and forth between private and public service jobs once you hit 120 payments. And they've already made one adjustment. I talked about the income-based repayment adjustment. There is an ongoing, through October of this year, adjustment to public service loan forgiveness, where they're doing a lot of the same things. They were saying if you were working for an employer but you were in the wrong program, they were going to give you credit, things like that. So some people got that one-time bonus that bumped up the number of months they were in forgiveness. And during that time period also, they were saying that you didn't still have to be working for the employer, a public service employer, but that's kind of over now. All right, other questions? You got a question? Yeah. Your payments will resume at the beginning of October. So usually it's October 1st. Most federal loan payments are due on the 1st. It may be a different day, but in the month of October, everyone is going to have a payment due. Make sure that you submit both your public service loan documentation to show that you're working for the employer, and you apply for your income-based repayment. One thing we haven't talked about yet is for income-based repayment programs, you have to certify your income and your household size. So you have to apply. So you want to do all of that in advance so that when this payment comes, it's an affordable payment. You're already in the program, whatever the program may be that works for you, and you can do all of that on studentaid.gov. Other questions? Josh.
Is the income requirement, is it based off of taxable income or gross income?
Is the income requirement for income-based repayment? Yeah. It is based on your gross income, based on your tax return, but also if you have income that's not reported, you have to report it separately. They basically ask you a question. Is your tax return accurately reflect your current income? If no, you submit proof of your current income. That also helps with people that income changes. So you say, well, I used to have a good job, but now I don't. I don't want a payment based on my own tax return. But for some people, it's as easy as them getting, you give them authorization to get your tax return from the IRS. They send it to the servicer and they'll use that for proof of income. Brian, you had a question.
Yeah, maybe a little more.
Sure.
With regards to bankruptcy,
Mm-hmm.
say because I've been getting these letters from private loan companies saying, hey, your student loan will get it at a lower interest, right? So I'm guessing they give you a loan, you pay off your federal student loans, and now your loans go down. So you don't get the benefits of the pause or the repayment program, anything like that. But does that new loan then become dischargeable?
Okay, so the question is, if you consolidate federal student loans into a private consolidation loan, is that new loan eligible for discharge in bankruptcy? Unfortunately, no. All student loans, federal student loans and private student loans, and even some debt to schools that isn't really a student loan, are not dischargeable in bankruptcy unless you meet that undue hardship test. A lot of warnings about those companies sending you letters. Luckily, the FTC's already gone after a bunch of them for false, misleading advertisements. Unless it is from your loan servicer or from the federal government, throw away any correspondence you get in the mail about your student loans. A ton of scam companies have made all kinds of promises about how we'll help you with your student loans. And the best case scenario is they actually do get you a new loan with a lower interest rate. But in most cases, they don't do anything at all. They may apply for you for income-based repayment, which you can do for free. And again, it's a super easy process. And then they'll charge you for it. Or maybe they won't do anything at all and they'll still take your money. So stay away from companies offering to help you with student loans. If you have private student loans, you just have to go directly to your lender or your servicer. No one's going to be able to help you with that. And if you have federal student loans, go to studentaid.gov and work with them and with your servicer. Any other questions? Jared.
Sorry if this was answered already, but if someone doesn't have income, they're under 65, they're homemaker, they're unemployed, you know what kind of plan they fall into?
Okay, so somebody who's not working, over 65. under 65, but a homemaker not working what program? I don't know what program's going to be best for them. A lot of programs are going to result in a $0 monthly payment and credit towards eventual forgiveness. That's where that student loan calculator at studentaid.gov comes in handy, because you will put in, I have no income. They will automatically pull the information about your student loans from your account, and they will tell you, this is the best option. Here are your other options. Here are all the things to know about these options. And with that information, you can then select which program works for you. And then they also have the form right there that you fill out and send to your servicer to get onto that program. So studentaid.gov is a great one-stop shop. Jenny, another question. Uh-huh. In that situation, if you have zero income, but your spouse has income, they are going to consider, in general, your household income. And Taylor talked a little bit about people with married filing separately. In some cases, by filing separately, you can only have them look at your income, but they will also not look at the larger household size. That gets really complicated really fast. And so I can't tell you whether that will be a better choice or a worse choice to both file your taxes separately and then apply for a program separately. For most people, just getting into a program, even if it's both spouses, because one of the things they do when you have two spouses with two sets of student loans is they will factor in your spouse's student loan payment in factoring your ability to pay. It's usually best to do just everybody applies for a program, gets onto a program, but I can't tell you in any specific case what makes the most sense. Any other questions? Oh, Taylor has something to add.
So for the question about payments resuming in October, the good news is that even though President Biden's cancellation plan has been struck down, the Department of Ed announced that there's a 12-month on-ramp when repayments restart. So from October 1st of 2023 until September 30th of 2024, borrowers who miss payments will not be considered delinquent, will not have those missed payments reported to the credit bureaus, and will not have their debt placed in default or reported to the credit bureaus. So this kind of gives borrowers a little bit of breathing space. But interest will continue to accrue during the on-ramp period, but it won't be capitalized. So there's not going to be that additional amount that kind of makes the loan balance balloon. So just there is some hope, even though the cancellation plan is not going to go into effect, borrowers still have a little bit of leeway during the 1-year period after. Well, thank you so much for joining us for the Lunch and Learn, and we're available anytime to answer questions. Just shoot us an email.